Legal presents Courts Roundup.
Hello, I am Tanya Chugh and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court holds that gratuity can be withheld for recovery of dues, including penal rent, overrules Jharkhand High Court order. Delhi High Court directs Aam Aadmi Party government to submit a status report on the review of its decision to reduce reservation in ICU beds for COVID-19 patients. Madras High Court settles discord between music director Ilayya Raja and Prasad Studios, allows Ilayya Raja a day to meditate in the music room. Supreme Court Bar Association objects at Delhi police raid at Advocate Mehmood Pracha's office, raises concern over ETA advocate incident too.
India Legal presents Courts Roundup.
A plea has been filed before the Supreme Court seeking directions to the centre and states to take appropriate steps to double the number of judges in the high courts and subordinate courts and implement a judicial charter to decide the cases.
The PIL filed by Advocate Ashwini Kumar Upadhyay has sought directions to the centre and states to implement the recommendations of Law Commission Report number 245 and take other steps in order to break even and dispose of the backlog in a 3-year time frame. According to the plea, the apex court, being the custodian of the Constitution, and shall issue proper directions for implementation of the judicial charter in all the courts to decide the cases within 3 years and to break even and dispose of the backlog by 2023. The plea has stated that the right to fair trial and speedy justice is a fundamental right under Article 21. Therefore, no procedure can be fair unless it ensures fair and speedy determination of guilt of the accused. Fair trial and speedy justice have been recognized as an inherent and implicit aspect in the spectrum of Article 21. In order to provide speedy justice to ordinary citizens, there is urgent need to reform the judicial system. Requires that justice should not only be delivered on time but also be easily accessible to people, particularly people from vulnerable sections of society. A thorough understanding of current shortcomings and future needs of the system must guide the approach to reform. The plea says that the process of reform must begin with an assessment of the country's need that the legal profession seeks to fulfill, namely the requirements across various levels of judiciary, gaps in criminal justice system, specific areas within the law which will require an increased number of practitioners in the near future. As part of judicial reforms, the lawyer community, which has often been ignored, should also be considered. Legal education and continuing professional development must create a socially sensitive lawyer of conscience, from where justice delayed is not an opportunity but a blemish on one's personal persona and a failure of the system of which one is an integral part. A similar plea was filed by Upadhyay in 2016 seeking court's direction to the centre to double the number of judges in the country, which was disposed of by the apex court with liberty to the petitioner to approach the court again. Bureau Report.
The gratuity money of an employee can be withheld and forfeited for recovery of dues such as overstaying in official accommodation, the Supreme Court has ruled. A bench headed by Justice Sanjay K. Kaul held that there is no prohibition against recovering dues including penal rent, the rent with penalty for overstaying in official accommodation, from an employee's gratuity.
The Supreme Court has observed that a gratuity can be withheld for recovery of dues from an employee. In this case, the Jharkhand High Court had rejected the contention raised by Steel Authority of India Limited that the company was entitled to withhold the gratuity of the employee from its retired employee. In this case, the Jharkhand High Court had rejected the contention raised by Steel Authority of India that the company was entitled to withhold the gratuity of the employee for non-vacation of the company's accommodation and no interest was payable on the same. The High Court has relied on 2017 Supreme Court judgment in Ram Naresh Singh versus Bokaro Steel Limited and others case. The court added that the reliance placed by the High Court on the case of Ram Naresh is misplaced, that it was not even a judgment but an order in the given fact of the case. In the said order, the court had held that Bokaro Steel Limited could not be retained the amount due to its employee on account of gratuity. In the said order, the court had held that the Bokaro Steel Limited could not have retained the amount due to its employee on the account of gratuity. The court, however, dismissed the writ petition, observing that the amount in question is also quite small and thus it is not a fit case for interference under Article 136 of the Constitution. The order settles a disputed point of law since the two-judge bench of the Supreme Court had previously taken a view to the contrary. A division bench in 2017 had ruled unfavorably against confiscating the gratuity of an employee on account of overstaying in official quarters after his retirement. It had ordered the immediate release of his gratuity and held only normal rent, not the penal rent, should be charged for the period he overstayed. However, the three-judge bench led by Justice Kaul has now held that any reliance on the 2017 order is misplaced, since it is not even a judgment but an order on the given facts of the case. It clarified that the 2017 order cannot be treated as a precedent. The latest case has arisen out of an order by the Jharkhand High Court which snubbed an attempt by the Steel Authority of India to recover penal rent amount amounting to Rs 1.95 lakh from an employee who did not clear his dues and overstayed in the official accommodation in Bokaro after his retirement in 2016. Bureau Report.
The Madras High Court has settled a discord between celebrated music director Ilayya Raja and the proprietors of Prasad Studios that would allow Ilayya Raja a day to meditate in the music room, where he composed his songs for the past 35 years as a condition to withdrawing cases filed over the denial of his access to the studio in 2019. Madras High Court resolves Ilayya Raja Prasad Studios dispute, composer to meditate for a day in his former haunt.
On the Madras High Court's last working day, it recorded a settlement between Ilayya Raja and the proprietors of Prasad Studios that would allow the music maestro a day to meditate in the music room where he composed his songs for the past 35 years as a condition to withdraw cases filed over the denial of his access to the studio in 2019. Justice N. Satish Kumar recorded the following before disposing of the suit between Ilayya Raja and Prasad Studios. That is, Ilayya Raja will be allowed to enter the room where he composed his music for the last 35 years so that he can meditate for one day. The studio proprietors shall make an endeavor to see that nobody is present inside room. The room originally used by Ilayya Raja now stood converted into an IT room. The court was apprised. When Ilayya Raja is allowed inside the room, nobody will be permitted inside the room. When Ilayya Raja is meditating inside the room, simultaneously the material belonging to him kept in a separate room at the same premises. At the time of Ilayya Raja's entry to the premises, only 3 members would be permitted to accompany him. That is, 1 personal assistant and 2 music assistants besides the commissioner. Ilayya Raja has told the court that he would withdraw all pending suits before the lower courts against the studio. The parties have agreed to bury their differences and give a quietus to the entire dispute existing between them. The date of entry into the premises shall be decided by the counsel appearing for the plaintiff and defendants in consultation with the advocate commissioner appointed by the court. Ilayya Raja can enter the premises between 9 am and 4 pm. The time may be extended but not beyond 5 pm. The Chennai Police Commissioner is to provide security and prevent crowds from causing any law and order problem when Ilayya Raja undertakes the visit to Prasad Studio. The matter had reached court after Elia Raja was denied access to the Prasad studio citing renovation work in 2019. It is reported that the maestro's offer to release the premises was also rejected by the studio. Bureau Report.
The Delhi High Court has directed the Aam Aadmi Party government to submit a status report on the review of its decision to reduce reservation in intensive care unit beds for COVID-19 patients to 60%. The order was passed by vacation bench of Justice Subramaniam Prasad in a petition preferred by Association of Healthcare Providers, challenging the September 12 order passed by the Delhi government on the mandatory reservation of 80% ICU beds for COVID-19 patients in 33 private hospitals. On the previous date of hearing, the court was informed that an expert committee had recommended a graded de-escalation of reservation of ICU beds. Since the decision of the government was awaited, the court had refrained from passing any orders in the matter. Subsequently, the recommendations of the expert committee were approved and adopted by the Delhi government. The decision was also placed before the court. In view of the review that is to take place on January 5, the vacation bench today decided to place the matter before the roster bench for further consideration. The matter will be heard next on January 8. The Delhi government order on reservation was stayed on the court on September 22. However, as the COVID-19 situation worsened in the national capital, the stay order was vacated by the division bench of the High Court. The Delhi High Court has issued direction to the Union of India to allocate a supernumerary medical seat to an Indian Council for Child Welfare Bravery Award winner for the MBBS course 2019, which under the reservation scheme was reserved for the National Bravery Awardees. The seat was reserved in the NSCB Medical College, Jabalpur, Madhya Pradesh. In terms of Government of India, Ministry of Health and Family Welfare Office Memorandum dated 16th August 2019. Division Judge Bench of Justice Asha Menon and Rajiv Sahai End-Law was hearing an appeal by the union against a single judge bench ordered the same court directing the allocation of the seat to the awardee. The government said to the court that though it had reserved an extra seat apart from the two originally reserved, in compliance with the single judge bench's order, it was opposing the allocation because while the awardee was the winner of the National Bravery Award instituted by the ICCW, a non-governmental organization, but with which the union had disassociated as far back as in the year 2018. This contention was rejected by the single judge bench, but the division bench said that even though it hasn't gone into the questions raised by the Union of India, it finds merits in their contention, subject to hearing the respondent. However, noting that inasmuch as there is no possibility of any other candidate being entitled thereto or being admitted therefore, the court directed the union to allocate the seat to the ICCW awardee. In the case relating to the Delhi police raid on Advocate Mehmood Pracha, Patiala House Court has instructed the police to preserve raid footage. Meanwhile, the Supreme Court Bar Association has condemned raid.
A Delhi court has directed the preservation of the entire footage of the police raid at the house of Advocate Mehmood Pracha. Udbhav Kumar Jain, Duty Metropolitan Magistrate, Patiala House Court, however, said that the question regarding supply of video footage to Pracha can be decided by the relevant court at an appropriate stage. The court was informed that the same was handed over to Malkana Department and was being maintained as per the applicable rules. The court also recorded that the report on the execution of the search warrant had also been supplied to Pracha. Meanwhile, the Supreme Court Bar Association has expressed shock, deep concern and dismay at the recent search and seizure conducted by Delhi police at Advocate Mehmood Pracha's office. In a statement issued, the SCBA has called the Delhi police raid on Pracha's premises an arbitrary, illegal and brazen exercise of brute power and actions taken by them contrary to law against members of the legal fraternity. SCBA has also condemned the brutal attack of Alor in Etah district of Uttar Pradesh by the local police who entered the house of the Alor, assaulted him and then lodged him and his entire family in jail. The SCB has stated the act of police violates the right of the accused to a fair trial guaranteed under Article 21 of the Constitution. The statement further asserts that advocates are entrusted with confidential information from the clients, which is a privileged communication. The actions of Delhi police in its attempt to seize the personal computer and personal devices of a law-taking subterfuge under orders of court is a gross violation of right to privacy, the statement adds. Pracha's office was raided by a special cell of the Delhi police. The police claim it was searching for incriminating documents and metadata of outbox of the official email ID of Pracha's firm. While raid was going on, Pracha told the officers that the order does not follow the seizure of his computers but only examination of them. Pracha later moved the Patiala House Court seeking a copy of the video footage of the raids. The court has asked the investigating officer to preserve a copy of the same while deferring the matter for further hearing in January. On December 24, the office of Advocate Mehmood Pracha, one of the lawyers appearing in the Delhi Riots and Citizenship Amendment Act cases, was raided by the Delhi police. Bureau report.
अब हमारे साथ जुड़ रहे हैं रोहित पांडे। रोहित, हमें बताएं कि प्राचा मामले में एससीबीए का क्या स्टैंड है?
देखिए, मैं आपको बताऊं, महमूद प्राचा, हम स्पेशली किसी का नाम लेके बात नहीं करना चाहेंगे, क्योंकि आई टेल यू वन थिंग, कम्युनिकेशन बिटवीन क्लाइंट एंड लॉयर is a privileged information, and therefore the police cannot force a lawyer to provide any such privileged information for the purposes of investigation. Therefore, Supreme Court Bar Association has strongly condemned the action of Delhi police, and the association also condemned the brutal police attack on a lawyer in UP. So that's why मैंने पहले भी बोला है कि हम एक इंडिविजुअल के लिए की बात नहीं करेंगे, हम बात करते हैं जो भी हमारा लीगल फैटर्निटी से जुड़ा हुआ बंदा है, कोई भी हमारा लॉयर है जो लीगल फैटर्निटी से है, उसको हम डिफेंड इसलिए करेंगे कि वो ड्यू प्रोसेस ऑफ लॉ उसको केस के थ्रू चलेगा। और एससीबीए सुप्रीम कोर्ट बार एसोसिएशन स्टैंड फॉर द राइट ऑफ लीगल फैटर्निटी ऑल अक्रॉस इंडिया and will always do so. And there is also, in violation of fundamental rights under Article 21 of the Constitution, a right to fair trial and right to access of justice are sacrosanct for the people of India. This is the thing.
धन्यवाद रोहित हमारे साथ जुड़ने के लिए। A petition has been filed before the Bombay High Court seeking establishment of benches of the National Company Law Appellate Tribunal at various locations including Mumbai. The plea filed by Mumbai-based lawyer Advocate Nikki Poker has relied on the Supreme Court ruling in the case of Swiss Ribbons Private Limited versus Union of India, wherein the court noted the submission of Attorney General K.K. Venugopal, who assured the court that the directions in another judgment of Madras Bar Association will be followed, and that circuit benches of NCLAT will be established. Poker relied on the ruling of Supreme Court in the case of Swiss Ribbons Private Limited versus Union of India, where the court noted the submission of Attorney General K.K. Venugopal, who assured the court that the directions in Madras Bar Association will be followed and circuit benches of NCLAT will be established. The plea points out that despite an e-filing training program in November 2020, the date of e-filing in NCLAT has not been facilitated, yet it is Poker's case that the mandatory requirement of filing hard copies was causing difficulty to advocates outside of Delhi. Poker has therefore sought court's intervention on the ground that in light of the present situation, litigants and advocates were at a distinct disadvantage. Recently, a petition was filed before the Supreme Court seeking direction to make the Chennai bench of NCLAT functional National Company Law Appellate Tribunal. A similar petition is also pending before the Madras High Court. That's all for Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.